I think it's incredibly risky for Sean Combs to have filed a motion asking for an acquittal and asking either for a new trial, as there was some type of spillover prejudice to Sean Combs. It's risky because what they're basically saying is that Sean Combs is refusing to take responsibility for his actions, basically saying he was still innocent after a jury found him guilty. That would give me concern. Why? Because judges, specifically federal judges, don't want to hear that when it comes to sentencing. We know that the prosecution is looking for 11 years. The defense attorneys is asking about 14 months, which basically means, hey, in a couple months he would get out because he's going to get credit for time served. We know that the federal probation office has made a recommendation between 4 and 6 years. So when you're looking at a sentencing hearing, you're trying to put your finger on the scales of trying to get the judge to lean one way or the other, trying to get him on your side of the fence to reduce the prison sentence for your client. But one thing that federal judges don't like is that when you refuse to take responsibility for your actions at the sentencing, a criminal case designed to punish. Is it harder to punish somebody that's sitting there saying, Judge, I messed up, I'm taking responsibility for my actions, I can do better? We haven't heard that from Sean Combs. He's basically making the argument that, hey, Judge, while this may not be prototypical and these freak-offs might not be forever, this was all about consensual adults. That was his closing argument. And by filing this motion for new trial, he's continuing to say that. Well, we know there's at least one person who's not having that, and that's Ms. Ventura. She's come out and what in the state of Florida we call a victim impact statement is saying, Judge, absolutely not. I want him prosecuted. This was not willful. This was against my will. There was financial obligations. The judge gets to weigh the totality of everything. He's going to weigh what the prosecution wants, what the defense wants, where the probation office is coming in, but certainly what the prosecution is going to hammer at the sentencing and argue is that he stands before the court still refusing to take responsibility on what they call decades-old crime and violence that he's always gotten away with, that he's above the law, that he's been able to do this with immunity. I don't know how this is going to be received from the judge, this last Hail Mary effort to get rid of everything, because the downside, the risk, and I'm sure the criminal defense attorneys weighed it, was, hey, could this backfire at sentencing? Could this look like we're still refusing? Are we giving a free one to the prosecution where they're going to grab it and they'll say, as we stand here today, even after all of this, after all the testimony, and the court said itself, the government proved the case many times over. In my opinion, that spells trouble. If I was a gambling man, I'd say look for the court to probably go somewhere in the middle with the probation recommendation. Not going to get the defense what they want. Not going to go with the full 11 years. He was acquitted of the bigger charges of racketeering. But for them to downplay that risky move, and I think you can look for the court, certainly go more than the 14 months the defense wants.